Are you afraid that filing Chapter 7 means you automatically lose your house and your car? A lot of people have that fear. The answer is more specific than a simple yes or no. Outcomes usually come down to a few facts, like whether payments are current, how much equity you have, and what you can realistically afford going forward. This video is general information. A consultation is how you get an answer for your exact situation. Chapter 7 can wipe out many unsecured debts like credit cards and medical bills. A mortgage and a car loan work differently because the lender has a legal right tied to that property. A discharge can remove your personal obligation on many debts. The lender's lien on the house or car is a separate issue. Keeping the property often means keeping the loan payments current. Start with a house. People usually want to know one thing: can I keep my home? A clear answer depends on three main questions. Question 1, are you current on the mortgage? Being current helps. Many homeowners keep their home when they are current and the equity is protected. Being behind can create pressure. Chapter 7 does not set up a long repayment plan to catch up missed mortgage payments. A lender can also ask the court for permission to continue foreclosure. Question 2, how much equity do you have? Equity is the home's value minus what you still owe on the mortgage. Equity matters because state exemption laws can protect a certain amount of equity. Exemptions may vary by state, so a local attorney needs to apply your state rules to your numbers. When the equity goes beyond what exemptions protect, the risk can increase. A trustee may look at selling property that has non-exempt value in certain cases. Question 3, are there other liens on the home? Some homes have more than one lien. A second mortgage, a judgment lien, or a tax lien can change the picture. A consultation helps sort out which debts can be discharged and which rights can stay attached to the property. Now, common house scenarios. Hearing examples can make this easier to understand. Scenario 1 is a homeowner who is current and has little equity or equity that is protected. In many cases, that person keeps the home and continues making the mortgage payment. Scenario 2 is a homeowner who is behind and cannot catch up quickly. Foreclosure may continue after the lender gets permission from the court or after the bankruptcy court case ends. Timing matters in this situation. Scenario 3 is a homeowner with significant equity beyond what the law protects. In some cases, a trustee may consider selling the home to access the non-exempt value. A lawyer can explain whether that risk exists in your situation. Now the car. The car question usually sounds like this: will they take my car? The same themes show up again. Payments matter, equity matters, and affordability matters. People usually fall into one of three paths. Path 1, keeping the car and keeping the loan. Some people keep the car and keep paying. That often means staying current and handing the lender's paperwork correctly. One option is reaffirmation. Reaffirmation is an agreement that keeps you legally responsible for the car loan after the bankruptcy. That choice can make sense for some people. It can also carry risk because you are putting responsibility back on the table for that debt. Another option is redemption. Redemption usually involves paying the lender the current value of the car in a lump sum. That can be hard to do, but it is an option in some situations. Part 2, surrendering the car. Some people decide the payment is no longer worth it. Some people have a loan that is far higher than the car's value. Surrender means giving the car back to the lender and removing the payment going forward. In many cases, any leftover balance on a surrendered vehicle becomes unsecured and it may be discharged. Your attorney can explain how that works based on the details. Part 3, dealing with late payments. Late payments can raise repossession risk. Bankruptcy can pause collection activity at the start, but lenders can ask the court to restart repossession in certain situations. Fast action and good guidance matters here. A quick way to think about your options. 2 questions can help you get your bearings. One question is whether you can afford the payment going forward without falling behind again. Another question is whether the home or car has equity that is protected under state exemption laws. A plan becomes clearer when those 2 answers are clear. Now here's what to know before you talk to an attorney. Preparation can make your consultation easier and faster. You can collect a recent mortgage statement that shows the monthly payment and the payoff amount. You can also note whether you are current or behind and the amount past due when you are behind. You can also pull a recent car loan statement that shows the payoff amount. An estimate of the car's value is helpful too. A list of other liens is also useful. Examples include second mortgage, tax lien, or judgment lien. Those details help an attorney give you real answers instead of general guesses. Fear grows when you do not have a clear path. Clear information changes that. I'm Kim Clenney with Clenney and Palmer Attorneys at Law. My law partner, Debora Palmer, and I have helped people for over 25 years. Schedule a free, no obligation consultation through the link in the description. You will get honest answers about how Chapter 7 could affect your house and your car, whether you qualify, and what next steps you can looks like for you. We're looking forward to speaking with you.